Good afternoon. We're delighted to have you here with us. And we have three cases on the afternoon docket, and we will hear them in the order in which they appear. The couple of things to remind you about, I guess. One is these arguments are live streamed. And for that reason, you should be extra careful about what you say, because once it goes out there on the internet, you can never get it back. So the other thing to think about is, of course, for the appellants, when you come up, please let us know if you wish to reserve any time for rebuttal, up to 5 minutes. Okay? Would you call the first case, please?
Secure Air Charter LLC versus Michael John Barrett Jr.
Good afternoon, Your Honors. Klein Preston for Secure Air Charter. This is an appeal as of right from the First Circuit Court here in Davidson County on a dismissal arising from the Tennessee Public Participation Statute 2017-104A, that's sec. And
excuse me, did you want to reserve any time?
Yes, I'm sorry. 5 minutes, please, Your Honor.
5 minutes.
We bring this appeal based on two primary reasons. Number one, we submit that it was error for the trial court not to grant our motion to amend that was pending shortly after the filing of the petition to dismiss. And then secondly, based on the, we submit the admission of a declaration by Michael John Barrett, the appellee in this case, in support of the petition to dismiss, which we raised, objected to based on evidentiary grounds. And so, respectfully, it's our position that it was an error for the trial court to, number one, deny our motion to amend. The motion to amend, the trial court held that it was futile, and made that determination after the trial court had already ruled on the appellee's petition.
Counsel, didn't the trial court also conclude that it was moot on the basis of that? And I see, in your briefing on appeal, there's certain push on the futility aspect, but I didn't see a challenge in the briefing to the mootness determination that the trial court reached. Why isn't that, with regard to the amendment part of your argument, why isn't that essentially determinative? And if you haven't challenged mootness, and essentially isn't it the obligation of this court to simply affirm based on the mootness rationale?
Oh, in this instance, no, Your Honor, because procedurally, the mootness came after the court had already ruled on it before ruling on our motion to amend. And so the court went ahead and put the cart before the horse, essentially, and said, even in their opinion, that we couldn't provide any evidence. They shifted the burden to us.
Isn't mootness here, though, in a matter of you have the petition filed under TPPA, granted, there's really nothing left to amend, and so it's your motion is moot at that point.
Well, it wouldn't be, because we had filed, and that's part of our issue on appeal, is we filed our motion to amend before there was a ruling on the motion to or the petition under the TPPA, and so there was this pending motion to amend that the court then, after it already ruled on at that point, then the trial court ruled on the TPPA petition, and then in its order said let's
say you're right about that. Assume for purposes of argument that you're correct. Don't we still have a problem that the trial court says as a basis of his ruling mootness, and there's not a challenge to that? I mean, maybe that was wrong, maybe the trial judge's decision, but aren't we kind of stuck here with that rationale, given that it doesn't appear to have been argued against in your briefing on appeal?
No, Your Honor, because with respect to our motion and our argument on appeal is that the trial court erred in not granting that motion. The granting, whether the trial court said it was moot, or whether it said it was futile, or whether the trial court denied it for any basis whatsoever, it was done improperly because, number one, Rule 15, motion to amend to be freely granted. It was a pending motion at the time of the ruling of the motion for the petition under the TPPA. And so based on that, Your Honor, because procedurally it was already pending motion, that determination had not been made prior, and so it was not moot at that point.
Well, what about the scope of our review here? I'm concerned about the 106 argument here. We're on an interlocutory review, statutorily created. The statute seems pretty clear what we're to review. It doesn't suggest to me that we can even look at the motion to amend.
Well, except for the motion in this case, or the order concluded the entire case, and not just, it's not interlocutory because it concluded all issues, because the trial court dismissed everything at that time, including our complaint at the time. And so there's nothing remaining to be done. There's nothing pending.
Is there not attorney's fee award to be decided?
There would be, but this court has held on other occasions that
You do it you do it later, but still, to me, this is not a rule. I don't even think we designated this as a Rule 3 on appeal. I mean, well, it's a Rule 3 in the sense it's appeal of a right because it's statutory, but I mean, what we're entitled to review is defined by that statute, 106.
the issue of attorney's fees has not been held to be an issue.
Well, just focus on 106, though. Under the language of 106, how do we get to the denial of the motion to amend?
Because this is a final order.
Okay, so you're saying
It's not an
we're outside the statute, so it's just like any other Rule 3 appeal.
Yes, because, Your Honor, they included in his order, the trial court did, that the complaint was dismissed and the matter's resolved. The only issue was attorney's fees. And in prior cases involving the issue of attorney's fees on the TPPA petitions, that has not been held to be a basis not to determine this a final order. And so on appeal, that's still a live issue. However, all other matters, except for that singular matter, have been resolved by that trial court's order. Otherwise, if we just dealt with it as if you address it this way, and you just dealt with it as an interlocutory appeal, let's say we didn't do anything on it and we didn't appeal, then what happens at a later date? The argument would come around, so it's res judicata is already, the time has lapsed, not res judicata.
So, but under your conception of the statute, as I understand it, it depends on whether or not you can get to things like a motion to amend that was filed in conjunction with the petition dismissal on the TPPA, whether or not the TPPA dismissal affects the entire case. In other words, would this be a different situation had they only successfully dismissed one claim under the TPPA?
Your Honor, I would submit that is a circumstance.
And in that case, in that sort of appeal, we would not get to a motion to denial of a motion to amend.
That's right. If there were other causes of action that were not solely encompassed within what they challenged under the TPPA, then our case would be different, because then there would be other issues and causes of action remaining. In this instance, I'd refer to it more of like a trap. If we had not appealed and brought these issues, then on remand from a so-called interlocutory appeal, then the argument would be, I'm certain, that, well, we can't appeal because we didn't raise those issues and those are final.
Counsel,
and this order creates.
Let me ask you about the issues that you are raising. Opposing counsel raises, you don't have a statement of issues in your brief. And they argue that under Rule 27, therefore we shouldn't consider your brief on the merits of it. What are the issues as you see them that you are raising in your brief that this court is supposed to identify? That's normally an opposing counsel, I'm sure, has already expressed concern in their briefing that they haven't had an adequate opportunity. what are the clearly stated issues as you see them in your brief?
Well, as stated in the title of each of the arguments we made, and which are also set out in the table of contents of our motion. One is the error that we allege was with respect to not being able or denying our motion to amend, number one. Then number two is the admissibility of the affidavit or declaration of Michael John Barrett Jr. And then secondly, that leads into the dismissal of the or granting of the TPPA petition. So those are clearly set forth in our brief. I would submit that based on that, I mean, the issues are presented to the court. The issues are stated and fully briefed and adequately so. And so each of those, respectfully, I would submit that argument is without merit because it's straightforward set forth. I would also draw Your Honor's attention to Rule 1 of the Tennessee Rules of Appellate Procedure, which suggests that the court should look to the merits of case. And so we would ask that if in fact you were to determine that our motion, or I mean our brief was not sufficiently I guess specific as to what the issues are, then I would ask you to employ Rule 1 to address the merits of the case on appeal.
Thank you, Mr. Preston. Your time is up.
Good afternoon, Your Honors. May it please the court, Daniel Horowitz of the Nashville Bar on behalf of the appellee, Mr. Barrett. I'm also here with my co-counsel, Sarah Martin and Laura Cantwell. This court should affirm the trial court's order granting Mr. Barrett's TPPA petition on multiple grounds. And very little analysis is necessary to reach that conclusion because overlapping waiver issues preclude this appeal in its entirety. I want to pick up where you just left off. The plaintiff has failed to identify in a statement of the issues any issue for review in this appeal. Based on that defect, this court should find waiver of all issues in this appeal and affirm for three reasons. First, controlling precedent from both this court and the Tennessee Supreme Court requires this court to find waiver of all issues here.
Counsel, doesn't de novo Binkley point to a different conclusion in terms of, and maybe it limits the issues that the court should consider here, but if insofar as you were able to identify that an issue was being argued and the court's able to understand that issue is being argued, isn't it really harmless? At least, I mean, it may limit what should be considered, but if you could tell that was being argued and were able to meaningfully respond and this court's able to meaningfully consider it, doesn't de novo mean we consider it and it's not waived?
I don't think so. Let me tell you why. So I recognize there is a November 2025 decision from this court, unreported, that says basically if the court can figure out what's going on from the briefing and the other side responds, then we're just going to overlook it.
And there's also the Supreme Court's order in Trevisan as well.
That difference between an incomplete or a less than specific statement of the issues and no statement of the issues, though, and here's why I flagged this. There are at least four, or there are many more than that, but let me give you 4 examples of controlling reported decisions that say waiver must be found here. So first, Hawkins versus Hart, 86 Southwest 3rd, 522 at page 531, decision from this court, quote, an issue not included is not properly before the Court of Appeals. There's also Childress versus Union Realty Company, 97 Southwest 3rd, 573 at page 578, quote, we consider an issue waived where it is argued in the brief but not designated as an issue. And then 2 Tennessee Supreme Court cases. Hodge versus Craig, 382 Southwest 3rd, 325, page 334. Appellate review is generally limited to the issues that have been presented for review. And then in 2023, the Tennessee Supreme Court, in a summary decision reversing this court, City of Memphis versus Edwards, applied this rule because the Court of Appeals, 2/3 of a panel, failed to follow it. So the unreported decisions that have said we can overlook waiver here, I think are in conflict with this controlling reported authority, so I think you have to apply the controlling case law. As to prejudice, though, there is actually prejudice here.
So, I'm sorry, Mr. Horowitz. I'm not sure I follow. The conflict is where, which, I guess?
Sure. So some Court of Appeals panels have said, if we can glean the
Oh, I
issue
see.
from
I
the
see what you're
brief,
saying. Okay.
right, we can still go on and avoid waiver. But there are all these controlling cases that say otherwise. You got to apply the controlling ones. There is prejudice here, though. We've listed on pages 20 to 22 of our brief at least 18 different substantive issues that are, scattered throughout the appellant's briefing. I cannot hope to guess which of those were actually presented here today. I was listening intently when you asked. I hear we're down to 3, but it's not my job to guess as to what the appellant is raising. The last thing I'll say on this point, the fatal error involved here is curable when an appellant wants to cure it. I want to call your attention to a different November 2025 case from this court. It's called Smithwick versus Smithwick, or I guess those are probably Irish names, so Smiddick versus Smiddick. Citation is 2025 WL 3152217. This court's case number is W 2024-00081. COA R3CV. I'm going to emphasize the procedural history here. Here's what happened. An appellant files a brief, has no statement of the issues in it. The appellee files its response brief. It says all issues are waived because there was no statement of the issues in the appellant's initial brief. Appellant, after having that defect pointed out, files a motion with this court saying, I want to supplement my initial brief with the statement of the issues. Here is a statement exhibited. This court grants the motion, and let me just read the holding that results from the opinion. Quote, as a threshold argument, father asserts that in failing to list her appellate issues under a statement of the issues section, mother has waived them. We disagree. By order of March 25th, 2025, this court granted mother's motion to file a supplement to her appellate brief with a separate statement of the issues, which she did. Accordingly, mother's brief is compliant with Rule 27, and we will address her issues substantively. In other words, when an appellee calls this defect to an appellant's attention, they have every opportunity to cure it. Plaintiff could have done that here. We filed our brief complaining about the missing statement of the issues back in August of 2025. Afterward, though, the plaintiff makes no effort to cure the error. Indeed, it doesn't even file a reply brief to clarify the issues presented here. So I come in here utterly unaware as to which of the 18 issues scattered throughout its brief will be presented.
Counsel, I have a question about, just shifting gears here a bit, into the 106 jurisdictional argument that you're making. I wonder if there's a distinction here between the mootness rationale and the futility aspect of this. So, language of 106, the court's order dismissing or refusing to dismiss a legal action pursuant to petition filed under this chapter is immediately appealable as a matter of right to the Court of Appeals. And the decisions are all contained within one order. But insofar as the attempt to amend is rejected based upon mootness, why isn't that something that's encapsulated in 106 in terms of the jurisdiction of this court to review?
I will step back and say I would prefer it to be true that this issue is before this court. And the reason was alluded to in your argument. There is no claim made based on this alternative mootness rationale. I would love to take this issue off the table, but I agree with Judge McBrayer, it's not actually within the scope of this court's review.
Why not? Why doesn't it fit within 106?
Because it's simply a denial of a motion for leave to amend. Right? And if you treat it a different way, you're going to have innumerable interlocutory TPPA appeals. Say the motion should be granted, and then we have a new case, and then there's another TPPA grant, and we keep coming up and down. That is not the way that this works, and we are very much in interlocutory appeal land here. There is still a motion.
So I want to explore the practical effect of that decision, though, what it means. You say innumerable things might come up as a result of a holding otherwise. So I'm only imagining, though, a couple, motion to amend and a request that was denied for additional discovery. What other innumerable things, what sort of disaster is going to happen here, Mr. Horowitz?
I mean, what about a Rule 59 motion, a Rule 60 motion, anything that is not the order granting or denying the petition? Literally anything else in the case could then be wrapped up in these interlocutory appeals, and you could have successive interlocutory TPPA appeals based on whether a motion for leave to amend is granted or not. I don't think that is within the scope of the rule. I just refer to the Tennessee Supreme Court's opinion and recipient of final expunction order in McNairy County, which limits the scope, the latitude of this court's review. But if I'm wrong about this, and I would prefer to be, the correct ruling is what you suggested earlier. Because there were two different grounds for denying the motion for leave to amend, and the appellant has only challenged one of them, you must affirm based on the unchallenged ground. That is the rule. It's from the Elephant Sanctuary's case, Tennessee Elephant Sanctuary versus Buckley. So you just simply affirm the denial of the motion to amend. If that's where this case ends up, I will have absolutely no problem with it. I don't see a denial of a motion for leave to amend being within the scope of the statute. To try to hit the substantive issues in this appeal, and I guess I should not even characterize them as substantive. Even if you address what the appellant has said is before you now, you still have to affirm on waiver grounds, because waiver rules still preclude this court from doing anything other than affirming due to the appellant's failure to appeal multiple case dispositive rulings. All the plaintiff apparently appeals here is the trial court's step 1 ruling under the TPPA and its decision admitting Mr. Barrett's declaration. But page 240 of the record confirms the trial court admitted 2 pieces of evidence to support its step 1 ruling. First, the defendant's declaration, but then second, the party admissions in the plaintiff's complaint. The plaintiff has failed to raise any issue on appeal about the party admissions in its complaint being used to support the trial court's step 1 ruling. The plaintiff's complaint was also explicit that the plaintiff is suing Mr. Barrett because he made, quote, reports to the Federal Aviation Administration regarding the plaintiff's business and operations and its, quote, safety procedures, which is sufficient on its own to support the trial court's step 1 ruling. As a result, again, the same controlling precedent requires this court to affirm based on the unchallenged ground. That's Buckley versus Elephant Sanctuary in Tennessee. Case citation is 639 Southwest 3rd 38 at page 55. Apart from that, though, there was no error in admitting Mr. Barrett's declaration. Mr. Barrett had personal knowledge of what he sent to the FAA and why, and his declaration said so. Given that, I am baffled by the argument that the declaration would or could be inadmissible here. So this court may affirm for that reason, too. That is the end of this case, Judge. If this court has any questions, I'm happy to answer them.
None seen. Thank you, Mr. Horowitz.
Thank you.
Mr. Preston?
Thank you, Your Honor. First, I'd like to point out there's a very distinctive difference in what Mr. Horowitz claims with respect to our the original complaint that was dismissed. It wasn't that we're suing because there were statements made to the FAA. It was because they were false statements, knowingly false, and that's a significant distinction here that I'd like to point out. That was also raised with more specificity in our first amended complaint, proposed one that the court denied as being moot. After,
Well, but, I mean, their burden on the motion to dismiss or petition to dismiss is just to show that the actions that they were sued comes within the ambit of the TPPA. I mean, it's a really small burden to have to overcome to show that you're within the statute. It's so broad. I mean, you know, what I would say to the response to this is, so what? So what if they were untrue? I mean, it's your stage there. Once they've fallen within the ambit, you've got to say, okay, it's false, and here's why that's problematic. I mean, right?
well, partially true. They're false, but our statements in our complaint are to be taken as true for purposes of the motion. And so, in addition to that, the burden shifts when the TPPA is filed with its supporting whatever, affidavits or whatever they want to support it with.
The burden's always, so they're in the ambit, even with a false statement made, because they're exercising their right to petition. And then you've got to come back with something, anything to say, hey, you know, this is why a false statement is problematic. It says, you know, makes a prima facie case for our claim. And there's nothing here.
Well, there's nothing there as far as the TPPA goes in their claim, respectfully, because in that Section A of the statute 2017-105A, it says that a party must show a party's exercise of the right to free speech, right to petition, or right of association. If you remove the declaration of Michael John Barrett, how does the court have information to show that there was anything that supported this right to petition? There's nothing in there.
Well,
in the record. And when
why
you look,
wouldn't the complaint here be enough?
because when you look at the complaint, it sets forth that the statements to the FAA by Mr. Barrett were false. There's no showing by counsel that this was a right to petition or violation of its First Amendment rights. All speech is not protected.
It is
And
not, but you.
And so they don't, I'm sorry.
Well, no, go ahead. Go ahead.
And so they don't rise to the level just simply based on our original complaint to satisfy this aspect of the TPPA. That's what essentially they're arguing. What we're saying, and what we said in our brief and at the trial court, is they had no proof, because that in and of itself, just the black letter language of our complaint does not satisfy this provision. And secondly, the admission of the declaration of Michael John Barrett was in error, because that petition was based on they failed to lay a foundation for who this gentleman was. There were no specific facts, predicate acts or predicate facts in the declaration to show what it was he made to the FAA.
Isn't it true, though, that the Constitution protects the right to petition, even if what you're petitioning for is ultimately determined to be unfounded?
Petition, but these were brought because of statements, and that's a difference. And
Isn't it also an act of petitioning? I mean, the FAA, you're petitioning a governmental entity to take action.
But we don't have. That's another aspect of our declaration, or objection to the declaration, because the declaration doesn't say in there specifically what
Your
he
complaint
stated.
says he's a pilot, right? And the declaration says I'm submitting safety concerns to the FAA. So what's the problem with the declaration then? I mean, he's a pilot, he's submitting safety concerns to the FAA.
Well, a significant one is there are no facts to set forth what he's laying the foundation for. Did he have personal knowledge of it? There are no statements as to when, what, where, by whom, who the author of the emails, because it refers to emails that he conveyed to the FAA. Emails about what? Could it have been about the food?
But, I mean, I guess the point is that even if these reports were, Secure Air is insisting that I put my landing gear down whenever we land, and I think that's a safety violation. You know, well, I guess that's a bad example, because that's probably a true statement. They probably do insist on that. At least I hope they do.
Probably not happened more than once.
Yeah, that's right. You only bent up one plane before they stop not insisting on that rule. But in any event, you know, that would be an unfounded petition there. There's no real true safety violation there. You want pilots to do that. But that still would come within the ambit of the TPPA, would it not?
In that circumstance, but in this circumstance, Mr. Barrett's declaration has no specificity as to what these emails or even what his complaints were. And so he could have been, there is absolutely not a single fact that's set forth in his declaration. In fact, he puts it all off on written documents that he submitted to the FAA without identifying who the author of them were, what they state, when, where, how. I mean, it was such a void of facts that declaration should have never been admitted. And it was woefully insufficient to support a TPPA claim and shift the burden. The burden never shifted, respectfully, to my clients. But we shouldn't have even had to get there, because the court respectfully committed error by not at least granting the motion to amend and then let them attack with their TPPA after that. In this instance, the court even made the finding. They talked about futility and mootness, but when you look at and read in the opinion by the trial court even says could not bring forth any proof in a case involving in an instance when we're arguing, let us amend because we have this document, because the amended complaint referred to a confidentiality agreement between Secure Air and this pilot. And that was the basis of it. It was a contract. And so in that contract, there were certain restrictions on what Mr. Barrett could and could not do with certain information. And so that was part of it, as a breach of contract claim. It was just a different claim than the original. And so in this instance, the trial court made findings without any, we had no opportunity to even put on any proof as to it, because we were attacked with the TPPA on our original complaint. And then the court says, well, it's futile and it's moot, and then even makes an evidentiary finding that there's nothing that could have been brought forward, claiming that the facts were essentially the same. But that's without giving us the opportunity to actually have that complaint before the court to argue and to reply in opposition to a TPPA petition, which was based on essentially nothing other than Mr. Barrett saying things that were totally conclusory.
Your time is up.
How do you add time? I don't see
It takes more than
put
a
a
quarter,
quarter.
I'll tell you
I
that.
can put- Thank you, Your Honor.
Thank you. Thanks to you too, Mr. Horowitz. Would you call the next case, please?
David Braden versus ARB Gaming LLC.